violation by hotels, restaurants, homestays in Mandarmani, Purvo Medipur. All stakeholders are hereby directed to demolish and clean your illegal construction within to area. So who are the stakeholders? What violations have been made by them? Nothing is there. A simple non-speaking order. This has been passed. Anyway, Milord. Now, Milord, this is on the basis, kindly see, on the basis of an order that is, Milord, starts from page, no, page 18. 118. Not police store, na. 120. Now, let's kindly see, this is a order for demolition by a joint committee constituted by the Honorable Green Tribunal Special in terms of order date 2 passed in connection with the original application regarding gross violation of mandate of law and non-compliance of the Supreme Court causing damage to coastal and marine ecology and environment, Mandarmani, Purvo Medipur, so and so. Now, your lordships will find from the, if your lordships come to page 131, I am coming to the big judgment. Then I am come to the order, or not order, judgment, sorry. Now, similar, the rest 120 hotels out of 143 hotels as per Annex 2 and Annex 3, except 23 hotels mentioned in table 2 lie on the seaward side within CRJ 2 or in the periphery of CRJ 1 and CRJ 1B. Therefore, the operational of this hotel, etc., is not in compliance with the CRJ notification amended. Appropriate actions as deemed fit and proper can be taken so as to make the CRJ free from encroachment as observed from these hotels, etc. Established and operated controlling of the CRJ notification amended. However, it may be mentioned 49 hotels out of 120 had been granted consent to operate as per the honorable answer. Now, what are the hotels? Which hotels have been got the consent? What are the norms? Nothing has been done. The most important point is, Milord, whether this committee is having any power of adjudication. If adjudication power is not there, how we can pass an order? Adjudication power is vested with the Green Tribunal. Green Tribunal has delegated the power to the Milord Joint Committee. Can it be done, Milord? Technical thing. A team. Can it, Milord, who will decide the dispute? Dispute will be decided by the statutory tribunal. Tribunal did not adjudicate. Tribunal didn't say which are the hotels have contravened the provisions, etc., etc. That has been delegated to a committee. Committee will earmark it. Committee will decide. Can the committee do it? And Milord, another, if kindly see just, lordships kindly come to, it starts from page, Milord, tribunal's order. That is the most important, Milord, and it starts from page 72, kindly come to page 72. See, my lord, this is the National Green Tribunal, Eastern Zone, Kolkata. See the, Milord, page 72. Order influence. Kindly come to page 78. Page 78. See, my lord, the Constitution. Page 78. Page 78. See, 5 members were there. Lord, this is not permissible under the Act itself. Okay.
4C.
First, similar 4C. 4C. The central government may, but in consultation with the chairperson of the tribunal, makes rules as to answer generally by practice to answer. Then see, the minimum numbers of members who shall hear the application and appeal in respect of any class or classes of applications and appeals. Then, Miller, provided the number of expert members shall in hearing an application or appeal be equal to the member of judicial members hearing such applications or appeal. Therefore, if there is an odd numbers, cannot.
Here it is 5, so it is odd.
It should be 6, 8, 4, whatever it may be. And Miller, I am fortified by a, on this point, a judgment of the Bombay High Court, Miller. Now, Miller, since I have come to the act itself, let me show your lordship, Miller. Miller, kindly come to section 14 now. Come to section 14. First of all, section 14.1, the tribunal shall have the jurisdiction over all civil cases where a substantial question relating to environment, including enforcement of any legal right relating to, is involved, and such question arises out of implementation enactment of the specified in Schedule 1. 2. Tribunal shall hear the disputes arising from the question referred to in subsection 1 and settle, my lord, here my important point is, and settle such disputes and pass orders thereon. Third, no application for adjudication of dispute under this section shall be entertained by the tribunal unless it is made within a period of 6 months from the date on which the cause of action for such dispute first arose. Then cause of action arose when the hotel was constructed, resort was constructed. And it started from 1996. How such a dispute can be entertained in the year 2019 or 2020, 18? Starting from commencement of 1996 to pre-2011, resorts have been made. আসছি দাঁড়া না একটু একটু থাম আমি বড্ড মোটা মোটা লোক আস্তে আস্তে যাই আমি
Yes.
Therefore, entertainability, tribunal had no power to entertain it. Next, Millard, that's the last resort can be taken. Now, Millard, the committee has decided this joint committee. Joint committee judge order is not even a reasoned order. Joint committee has not identified. Joint committee has not entertained any claim. Joint committee has not. What is the reason? Whom they have? What are the evidences have been considered? Asti. Now, most importantly, CRJ notification has not been made so far West Bengal is concerned. The question of breach doesn't come at all. Now there are numbers, but I do not want to take much of your lordship. Let me frame the questions to your lordship before your lordship for considerations to your lordship. If a committee doesn't have the power for adjudication, can he pass to demolish? Power which was vested with the tribunal under the Act has not exercised the power. And the section 20, the parameters which have been there simply have been quoted. Parameters have not been considered. Therefore, whether it's a nullity or not, and the moreover, the point is 5 persons, that's a nullity itself. Committees, formation of the bench itself is a nullity. Now, just 1 minute. Lordship knows the blood. I am aware about this blood. Now, Lordship knows this blood that even order is without jurisdiction, writ court can entertain the matter. Law is well settled. I also take this point in collateral proceeding also. Writ court function and duties of the writ court ultimately is to see the substantial things. If an adjudicating authority does not discharge his duty delegated, that's a very simple thing. It's a totally illegal. Dispute was required to be heard. Now, I will show to your lordship just 2 judgment. Whirlpool judgment is there. That is 1998 one SCC judgment. 1998 one SCC. Whirlpool judgment, lordship knows that the Tatri down away. There are long pending, long years. 6 months cause of action. Where is that pleading in the petition application, original application? Yeah, no. This during the last 6 months, this construction has been made. All these constructions have been made long back, right from 1996 to up to 2009, 10, 11, 12. Applications have been filed in 2018 or 19.
Application for what?
Before the tribunal. Before this is on before the on the basis of an application filed by someone. The entertainability point. Now, lordship knows that principles, when here, the almost 140, 2040, they have invested huge money. A good numbers of workers are going on. Practically, it has become an industry there, a tourism industry. Livelihood of all the persons can be taken away. With an alternative, I am submitting that if your lordship ultimately comes to an finding that's taking into consideration of the principles of the Act itself, that these are the things can be fulfilled. That's section I was reading. That section
is that the NGT could not have delegated its authority to adjudicate upon a committee. Stop. Paragraph. Further submission is that the cause of action arose long back, and as per the National Green Tribunal Act 2010, the demolition of the construction which are used by the petitioner for running their business. Accordingly, the interim order praying stay of operation of the impugned notice is allowed. Stop. The impugn notice dated 11th November 2024 shall not be given effect to till 13th of December 2024 or until further order, whichever is earlier. Stop. The respondents are directed to file a report with regard to the averments made in the writ petition by 4th of December and serve copy upon the learned advocate representing the petitioner. List the matter on 10th of December.
But shall we submit a reply to the if it's
Prior
necessary?
to that, you can do it. No difficulty.